Yat and Nana, welcome back, relatives. We are going to jump into the next portion of our session together, a presentation by Mary Kathryn Nagle, who is an enrolled citizen of the Cherokee Nation and also a partner at Pipesteam and Nagle Law PC, where she works to protect tribal sovereignty and the inherent rights of Indian nations to protect their women and children from domestic violence and assault. She will be doing an overview of the Reauthorization of the Violence Against Women Act. Mary, you can take the floor.
Great. Oh, there's an unmute button that flashed in front of my screen. Okay, sorry. Okay. Good morning, everyone. Thank you so much for having me here. I should note, I'm actually not a partner at Pipesteam Law. I'm no longer affiliated with that firm. Nothing huge there. I just don't want the record to be wrong since I am no longer have any affiliation with that law firm. But I am still outside counsel to the National Indigenous Women's Resource Center and have dedicated much of my work to the Violence Against Women Act and to issues that relate to sovereignty and safety for Native women. So it's an honor to be here. Thank you so much for inviting me, to discuss this critical restoration of tribal sovereignty and jurisdiction that we just won in the most recent VAWA reauthorization. It's an incredible, incredible victory, and I'm excited to be here to talk about it. Just a little bit about me. I'm a citizen of the Cherokee Nation. I was born in Oklahoma originally, but today live in the DC area. And again, just very much appreciate the opportunity to talk about this. So I'm going to jump right in because I don't want to make you all any later than we already are. And I will say there is a lot to discuss in this most recent VAWA. Like 99% of it is absolutely fantastic. And so it's a very exciting time for sure. So let me share my screen. Oops, okay. View slideshow. So here is the PowerPoint. I have my contact information down here at the bottom. Please feel free to email me if you have any questions about anything that's discussed in this presentation. Now, what is so amazing about VAWA 2022? Well, as most of you know, the Supreme Court in 1978 eliminated tribal criminal jurisdiction over crimes committed by non-Indians. That was a very unfortunate decision known as Oliphant versus Suquamish Indian tribe. It put our tribes in a situation where they became the only sovereign within the United States that didn't have full authority to protect their citizens living in their own homes from anyone who wanted to come into their home and commit a crime. It's one of the main reasons why we have a huge public safety crisis in Indian country and so many crimes committed against our citizens, because as the Department of Justice has noted through its statistical data and research, the majority of violent crimes committed against Native victims are committed by non-Indians. So Oliphant was pretty tragic. The good news is that Congress has been working consistently to restore the jurisdiction and sovereignty that Oliphant took away. And so for those of us who remember VAWA 2013, that was an incredible victory. And in VAWA 2013, the United States Congress and President Obama signed into law a law that restored tribal criminal jurisdiction over non-Indian crimes of dating violence, domestic violence, and violation of protection orders. And you'll see them here under 25 USC 1304 as subsection C, D, and I. And they're spread out now because we have many more categories of restored tribal criminal jurisdiction now in 2022, which is wonderful news and is the result of the hard work of many tribal leaders, the National Indigenous Women's Resource Center, National Congress of American Indians, scores of tribal coalitions, victims, survivors, advocates who have been advocating for these additional categories of restored tribal criminal jurisdiction. One thing that was very apparent after VAWA 2013, obviously it was a huge step forward, but one crisis was that there were many instances, as we know, when domestic violence is being committed in the home, where children are also victimized or children are witnesses and therefore victims to the violence. But with just VAWA 2013, tribes still did not have jurisdiction to prosecute non-Indian crimes against children or any kind of violence or abuse or neglect of children. That has been added to this restoration. You'll see here under subsection B. That's wonderful news. Also, assaults of tribal justice personnel. This is critical because so often when our tribal justice law officers show up at a crime scene in response to a call for help, if it's a non-Indian perpetrator, that non-Indian perpetrator can abuse, beat, assault tribal law enforcement, and the tribe has no jurisdiction to prosecute that crime, which seems really counterintuitive. Like how can you have public safety within a community if there are segments of that community that can literally violently assault your public safety officers and there's nothing you can do about it, right? So that was a critical component of this VAWA 2022. One important piece is an exception to this restored jurisdiction in 2013, and an exception that remains today is if the victim is non-Indian. So Congress has said, if the perpetrator is non-Indian and the victim is non-Indian, no tribal jurisdiction. That was also a problem for us in fighting for VAWA 2022, because so many of our law officers are not tribal citizens, they're non-natives, right? Who come to work in our communities, who believe in protecting the safety of our communities, and our tribes, our government should be able to protect them if they're going to serve our nations. And so we wanted to make sure there was an exception such that if a non-Indian perpetrator assaults one of our tribal law officers and that law officer isn't an Indian, our tribal nations can still prosecute that crime. C is dating violence. This was in VAWA 2013. One thing that was limiting about dating violence and domestic violence under Section D that was also covered in VAWA 2013 is those necessitate some sort of relationship. So let's say, for instance, where we know in many instances there are high rates of stranger sexual assault or rape, where non-Indian men will come onto tribal lands or reservation lands, rape women and girls and leave, whether it happens in all forms and in all locations within a reservation. Many of our communities are well aware of this phenomenon. It can be even heightened when you have situations like a high level of extractive industries where you have large man camps or other transient populations, and you have individuals who really don't have a lot of accountability to the community. They didn't grow up there. They don't permanently reside there. They're just passing through. Under VAWA 2013, if one of those scenarios, a non-Indian raped a Native woman or child, or if a non-Indian raped a Native man or two-spirit relative, tribe would not have jurisdiction to prosecute that case because there wouldn't be a domestic relationship. In order for the tribe to have jurisdiction, there had to be a dating relationship, a marriage, a partnership, however the tribe defines it as a jurisdictional element. That was very limiting. But what we see here now in VAWA 2022 is this category of sexual violence. And I'll get to all the definitions of these categories in just a minute. This category is really significant because, again, it covers those scenarios where someone is raped by someone they aren't dating or don't have a consensual relationship with or any kind of intimate relationship with. It also relates, we also have sex trafficking that's now covered. This is really significant. We know that our women and children, especially, and our two-spirit relatives are more likely to be sex trafficked than any other population in the United States. This is a huge crisis in Alaska as well. And so now our tribes have jurisdiction to prosecute that crime. It also includes stalking. And this is important too, because we know that stalking is a precursor to way more serious forms of violence and oftentimes homicide. And so when law enforcement and tribal nations can prosecute for stalking, we will be saving lives because we will be taking harmful, dangerous people off the streets before they can kill their victim. Finally, E, obstruction of justice. So this is a crime that you may have heard about it if you watch like Law and Order or any of those legal procedural shows. But for instance, destroying evidence, that constitutes obstruction of justice. Instructing witnesses to lie on the stand, There's a lot of different ways you can obstruct justice, but the point here is this is now a covered crime because some of our tribes that have been implementing VAWA said they had some problems with this and that non-Indian perpetrators could do whatever they want to obstruct justice. And the tribe couldn't prosecute them for that. And the United States attorney was not going to prosecute them for that. So this was a really important category. It includes non-Indian victims as well. In this category, because keep in mind, again, for all these other categories that I just mentioned that are here on the screen, if the victim is non-Indian, then the tribe doesn't have jurisdiction. Finally, under I, violation of protection order, that's the same as it was from VAWA 2013. That is a holdover. So essentially, we have three of the same crimes, restored criminal jurisdiction categories that we have from 2013, and we added six very significant new categories. So I think it is a moment in Indian country for us to step back. I know so many of our families are suffering. We have a lot of trauma still being inflicted on children and family members to this day. But at the same time, it's important to celebrate our victories. And I think this is a victory that every single tribal leader, especially our tribal coalitions, our victim advocates, and our survivors should be celebrating, because it's because of your hard work that this has even been possible. I'm going to go through some of the definitions just so we can get a good look at them. Child violence, what does that mean, right? Because for those tribes who have been implementing and who wish to implement VAWA 2022, it's in terms of how you craft your code and how you define the laws, you want to make sure they comply with the actual language in the statute. So child violence is a crime where jurisdiction has been restored. It states, and this is in VAWA 2022, keep getting my tongue all twisted up over that. Child, the term child means a person who has not attained the lesser of the age of 18, and except in the case of sexual abuse, the age specified by criminal law of the Indian tribe that has jurisdiction over the Indian country where the violation occurs. Now that's what does that mean? When you break it down, it means that a child is someone who's under the age of 18, but in the case of sexual abuse, tribes can define child to be 21 or 20, or because it specifically refers to that if it's a case of sexual abuse, whether or not someone's a child is going to be, quote, the age specified by the criminal law of the Indian tribe that has jurisdiction over the Indian country where the violation occurs. So that's just something to keep in mind as tribal leaders, as victim advocates advocating with your tribal governments to get the right law in place to implement this, is that it's, the tribe has sovereign discretion in determining when we're talking about sexual abuse, is it younger than 18? Is it younger than 21? You could say whatever age the tribe determines, right? And child violence is defined as, the term child violence means the use, threatened use, or attempted use of violence against a child prescribed by the criminal law of the Indian tribe that has jurisdiction over the Indian country where the violation occurs. Now, this is important because this language, prescribed by the criminal law of the Indian tribe, means that Congress is deferring to tribes to define what is a crime of child violence. And in terms of use, threatened use, or attempted use of violence, I've had many conversations with many of us, the different folks who were working with people on the Hill to draft this language. And I can tell you it was very much the intent of everyone that this would also include criminal neglect of children. So you don't have to actually hit a child. Let's say if you refuse to feed a child for however long until they're starving to death or just have been horrifically abused as some form of cruel and unusual punishment, right? That's typically defined as criminal neglect under the law. That would fall under the scope of child violence, but you would have to spell that out in the code, right? The tribe would have to say child violence means, sexual abuse, criminal child neglect, violent abuse, like however you would spell that out. You just have to include it. But I think it's important to know that discretion is left up to the implementing tribe. Assault of tribal justice personnel. I talked about this a little bit earlier, and this is defined as, quote, the term assault of tribal justice personnel means any violation of the criminal law of the Indian tribe that has jurisdiction. Again, referring back to the tribe, any violation of the criminal law of the Indian tribe. Okay, it is letting tribes define what tribes mean by assault of tribal justice personnel that has jurisdiction over the Indian country where the violation occurs, that involves the use, attempted use, or threatened use of physical force against an individual authority. This is like under my video, I can't actually read. Authorities act for on behalf of that Indian tribe or serving that Indian tribe during or because of the performance of the duties of the individual. So I think it's really important too that this includes, when we talk about tribal justice personnel, it's not just law enforcement officers. So you'll see here in the definition, it includes people who are involved in preventing, detecting, investigating, making arrests, prosecuting a crime. It would include your prosecutor, right? Adjudicating, it includes tribal court judges. So if a non-Indian perpetrator is in court being arraigned and goes up and tries to punch the judge, that you can now prosecute that person for assault of tribal justice personnel. Detaining, providing supervision for tribal jails. Okay, if one of your officers working within a jail is assaulted by a non-Indian, your tribe now has jurisdiction to prosecute that. Incarcerating, supervising, providing treatment for, providing rehabilitation services for. So some of our tribes are starting to implement restorative justice programs and other rehabilitative measures that I think are really wonderful and are helpful in, trying to heal people, right? In addition to holding them accountable for their illegal crimes. But it's very important, right, that if a perpetrator does something to assault or try to threaten someone who's providing those rehabilitation services, the tribe now has jurisdiction to prosecute that crime as well. Domestic violence. Now, I'm putting this up here. Remember, domestic violence was in VAWA 2013. So why have I highlighted it here? Because the language defining it has changed. And this was also at our urging, because before there was a whole definition of what domestic violence is. And now we have this language that says the term domestic violence means any violation of the criminal law of the Indian tribe that has jurisdiction over the Indian country where the violation occurs. Okay. This goes back to deference to the Indian tribe. We've had many discussions of what constitutes domestic violence. Could it be destruction of property? Absolutely. I think any advocate that works in this field would say that is what perpetrators do when they're trying to abuse their victim and control and exert power in a manipulative way over their victim. They might destroy their property. But there have been questions in the past, because some of the language was more restrictive. Did the language that we had in the previous VAWA require the non-Indian to use actual force? Does there have to be actual force on the victim's body or person for it to be domestic violence? And so Congress wanted to make sure that no, that's not the case. And really, Congress is deferring to tribes to define what constitutes domestic violence, keeping in mind that the perpetrator has to be, under this law for it to apply, a current or former spouse or intimate partner of the victim, a person with whom the victim shares a child in common, a person who is cohabitating or who has cohabitated with the victim in the past, and a person who is similarly situated to a spouse of the victim under the domestic or family violence law that the Indian tribe, and again, refers back to the Indian tribe's own laws and defining, who can have a relation to under tribal law. So I think this is a really important update to the definition of domestic violence, and one that everyone should take into consideration. And it might necessitate or suggest updating your domestic violence code as well, even though that's not a new category of restored tribal criminal jurisdiction. And it was obviously in VAWA 2013. Sex trafficking. As I mentioned before, tribes can now prosecute non-Indian perpetrated crimes as sex trafficking. What is sex trafficking? Well, VAWA tells us that, quote, the term sex trafficking means conduct within the meaning of section 1591A of Title 18 United States Code. So I included here 1591A, and you can read here, it's a very involved and detailed definition, broken down into A1 and 2, but specifically whoever knowingly in or affecting interstate or foreign commerce or within the special maritime and territorial jurisdiction of the United States recruits, entices, harbors, transports, provides, obtains, advertises, patronizes or solicits by any means a person, and you can, I won't read the whole definition, but you can certainly take a look at this, and this will be very helpful in drafting tribal codes that implement this restored tribal criminal jurisdiction over non-Indian crimes of sex trafficking. But I want to also just highlight how broad it is in terms of tribes can now prosecute people who advertise for, the sex trafficking, who transport a victim, even if they, so long as they're doing it knowingly. Okay, it has to be knowingly. But this is really, I think, very helpful in terms of empowering tribes and restoring their inherent right to protect tribal citizens from these sorts of crimes. Sexual violence is also included. Just like child violence, it really refers to, prescribed by the criminal law of the Indian tribe that has jurisdiction over the Indian country where the violation occurs. And it includes in any case where the victim lacks the capacity to consent to the act. So, that's something to consider as well as tribes draft their codes, but it's really up to the tribe to decide what all is included in sexual violence. And I think that those will be some really important discussions to have and really important decisions for tribes to make. Stalking, another category of restored tribal criminal jurisdiction over non-Indian crimes. The term stalking means engaging in a course of conduct directed at a specific person prescribed by the criminal law of the Indian tribe that has jurisdiction over the Indian country where the violation occurs, that would cause a reasonable person to fear for the person's safety or the safety of others, or to suffer substantial emotional distress. So that's a pretty common standard in different states and under different laws and jurisdictions, is this reasonable person standard. But really at the end of the day, that stalking is what the tribe decides under the criminal law of the tribe to classify as stalking. And so I just encourage our tribal leaders to really engage with our victim advocates in drafting these codes. Our victim advocates have significant experience with victims of stalking. And I think this is one of those areas of the law where if enough attention isn't paid to drafting the laws around it, we can inadvertently exclude conduct that is really harmful, manipulative, abusive stalking, and conduct that can escalate to more violent forms of crimes, including assaults and homicide. So great opportunity in this restoration of tribal criminal jurisdiction to get at a category of crimes that have really gone unprosecuted in Indian country. And I just really hope that we'll see that collaboration that we saw in VAWA 2013 between our tribal leaders and victim advocates. Let's just step up. So again, amazing, right? What VAWA 2022 does. It is a huge victory. It's a bipartisan victory. It's something that, our tribal leaders and victim advocates and survivors worked for hard across the entire country. But there are a few things it did not do. And I think it's important just to be sure we understand what it didn't do. First, it did not fix all the font. VAWA did not restore tribal criminal jurisdiction over all crimes committed by non-Indians. There are still many categories of crime, basically anything that's not listed in that 9. And that 9 that I showed on the very first slide is under the definition of covered crime in Title 8. And that's another thing I should have mentioned. The tribal title in VAWA 2013, we all called it, and it was Title 9. It has now been moved as to Title 8. So the tribal title is now Title 8. This most recent VAWA does not rescind PL 280. It's important to note, though, that the restored tribal criminal jurisdiction is concurrent. So this jurisdiction does not erase or eliminate any federal or state concurrent jurisdiction. It simply restores tribal criminal jurisdiction. It's important to note that this VAWA does not include elder abuse. And that's, I will say, most of what I'm sharing with you today is a reason to celebrate. This has been a huge disappointment. I want to thank all the tribal leaders who submitted letters to the Senate Committee on Indian Affairs back in December, because our House version of the bill that we worked on included elder abuse, HR 1620. But when we got to the Senate Committee's bill that they put out, that Chairman Schatz and Vice Chairman Murkowski put out in December, did not include elder abuse. We asked that it be included. To be quite honest, we were never given a straight answer as to why it could not be. It just was not. And we were sort of given the option to oppose all of VAWA or just accept the fact that elder abuse would not be in there. And when I say we, I said one of my clients, the NIWRC, decided let's not oppose all of VAWA. It's very disappointing. We've demanded that elder abuse be added, but we can't let all of VAWA fall down. So this is just another one of those categories of critical jurisdiction that we're going to have to continue to work to restore. VAWA is not automatic. Each nation chooses to exercise this restored jurisdiction. And just so you know, we had a pilot project in 2013. So when VAWA 2013 passed, the first tribes that implemented that jurisdiction were 3 tribes that were approved by the DOJ to be a part of the pilot project. And then within that first year, 2 more tribes came on board. And so by the end of the first year, we had 5. That is not the case anymore. You do not have to get any kind of approval from the DOJ. There's no pilot project. You just do it. Of course, you have to look at VAWA 2013 and TLOA, those standards that are still in VAWA 2022. There's a lot of things that if you have not implemented VAWA previously, you'll need to update your codes and just ensure that you have certain things where you're meeting the requirements like every defendant, non-Indian defendant, must have a public defender assigned to him or her or have an attorney. The non-Indian defendant has a right to a jury that constitutes a fair cross-section of the community. So there's different requirements like that that you'll just want to make sure you're complying with. Important dates. So really important to note, VAWA for the restored tribal criminal jurisdiction does not go into effect from VAWA 2022 until October 1st, 2022. So tribes can implement VAWA 2013 today, right now, tomorrow. But the 6 additional categories that are in the most recent VAWA, tribes cannot implement those until October 1st, 2022. What I encourage folks to do in the meantime is to communicate with one another, work with one another, educate ourselves, and let's draft those codes. Let's update those codes. Let's get sex trafficking. Let's get stalking. Let's get obstruction of justice on the books, child abuse, right? Sexual violence. Let's, create all those codes, get them in place. We'll have plenty of time to work on them. That way, once October 1st comes around, we're ready to hit the ground running. A major victory in VAWA 2022 is that Alaska tribes can now implement this restored jurisdiction. So keep in mind, VAWA 2013 did not include the tribes in Alaska. They were excluded. This new VAWA in 2022 has a pilot program that allows them to implement this jurisdiction. And that pilot program went into effect on March 15th, 2022. So that is currently underway. There's a lot of additional support in this VAWA, which is really critical. One thing we were telling Congress is that, Congress has a trust duty to support and fund tribal governments, a trust duty and responsibility. And to date, tribal governments have been underfunded for public safety purposes. And so Congress heard us and they answered by giving the Tribal Access Program $6 million in funding, and the Tribal Access Program has been updated. It requires now the Attorney General to provide TA training assistance to the BIA and to law enforcement agencies on how to use TAP, and it removes the requirement that it's only for tribes that have criminal jurisdiction over Indian country, which was something that prevented tribes in Alaska from being a part of the TAP program. So if your tribe is not currently a part of TAP, TAP is an access program to a national criminal database that allows you to upload protective orders, data on prosecutions and convictions for different people, so that when perpetrators go into different jurisdictions, their former prosecutions and everything else will follow them. Or if your tribe is wanting to look up someone, you can access the database. I think it's been really helpful to the tribes that have been able to access it. So I encourage you to reach out to the Office of Tribal Justice at the Department of Justice and inquire how you can take advantage of this. Another program that's in VAWA is the Bureau of Prisons, and this program has now been made permanent, which is really great news. Before it was something, it was a part of TLOA, the Tribal Law and Order Act. And so it had to be reauthorized, and it had run out and was no longer in effect. And several tribes were really experiencing some hardships because they could no longer use the federal prison systems for their convicted criminals. So it is permanent. The other thing is that the sentence requirement has been lowered from 3 years to 1 year. So before, the BOP would not accept an inmate if that person was not sentenced to 3 years. So that was problematic. And the tribal prisoner cap stays at 100 people. Additional victories. VAWA 2022 explicitly applies to tribes in Maine. This is a huge victory because tribes in Maine were also excluded in VAWA 2013. And I know the tribes in Maine fought really hard to be included this time around. And many thanks to all the tribal leaders and tribal advocates, victim advocates, and survivors throughout Indian country who told Congress, no VAWA without our sisters and brothers and relatives in Maine who need to have the same ability to protect their own citizens as we do. And so thankfully, this VAWA is now open to tribes in Maine. As I mentioned before, the Alaska Pilot Project, this is a huge victory because tribes in Alaska were also carved out in VAWA 2013, and they faced some of the highest rates of domestic violence, sexual assault, and homicide in the country. So they are now included. There are still some exceptions where the restored tribal criminal jurisdiction does not apply. One is if the victim, or actually the only one that still applies, is if the victim is non-Indian. And as I mentioned before, that there's an exception to that exception, which is just what us lawyers love. And so the exception to the exception is if the crime is obstruction of justice or assault of tribal justice personnel. So for those two crimes, if the victim's non-Indian, the tribe still has criminal jurisdiction. But for instance, if it's stalking, if it's sexual violence, if it's child violence, and the victim is non-Indian, the tribe does not have criminal jurisdiction, unless the perpetrator is native, but that's a whole other conversation. There's no need to restore tribal criminal jurisdiction over crimes committed by Indians under VAWA because tribes have that jurisdiction. Something else that's really important to note is that the sufficient ties has been struck. So if you look at VAWA 2013, individuals could really only be prosecuted for crimes if they had a specific relationship, like an employment with the tribe, or other forms of relationship with the tribe. That requirement has been struck. And what's really important about that is that means that when individuals who have no ties to the tribe, who maybe come onto a tribal land just to game at the casino or just to drive through, if they decide to stop along their way and sexually assault a native person, the tribe can still prosecute them, even though there is quote unquote a lack of sufficient ties. The other thing that's really important and is a huge victory is the additional funding in this VAWA. Specifically, we're looking at a $20 million increase. Now, many tribes implementing VAWA said 5 million is not enough because each tribe is only getting a few $100,000 worth of grant funding. And as you all know, running a court in a tribal justice system takes a lot more money than that. This still will not be enough, I know, for those tribes that are implementing this restored tribal criminal jurisdiction, but at least it is now 25 million. So I really do encourage tribes to apply for these grants from DOJ and BIA, but specifically DOJ, OVW. The other thing that's really important is that the Attorney General now has to create a program for reimbursements for non-Indian healthcare costs. Some of our tribes that were implementing reported that the non-Indian perpetrators of violent crimes would injure themselves and then they'd be in jail and the tribe would be required to pay for their healthcare, or let's say they just have a health issue that arises while they're incarcerated. Now the tribe is out, how many hundreds of thousands of dollars to pay for someone's expensive surgery or healthcare. And IHS doesn't cover it because they're non-Indian. And so what Congress has done is created a reimbursement program so that if the tribe has a cost like that, that's unexpected, that can't be budgeted for, right? Like you can't predict how many DV perpetrators are going to break their hand punching a Native woman next year and then require our tribe to do hand surgery for them, which is what Eastern Band Cherokee was faced with. This is the kind of cost that you can, once the tribe expends the funds, can go to the AG and say, here's my receipt, here's the invoice, please cover these costs. And they're supposed to. The AG is, the Attorney General. Finally, I will note that there are new habeas provisions in this bill that were not in 2013. So this is important to note. One of the most important things is under G, notice habeas corpus petitions. It reads, a participating tribe that has ordered the detention of any person has a duty to timely notify in writing such person of their rights and privileges under this section and under section 203 of the Indian Civil Rights Act. So very, 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 very important to get that notice in writing and timely. Now, we don't have a definition for timely here, but let's not leave it up to the federal court judge to decide that it wasn't timely if we waited too long. I would suggest that, as soon as anyone's indicted or charged with a crime, that you just provide them with a piece of paper in writing that tells them that they have a right to file a habeas corpus petition. Now, one good thing that this law does is it codifies the requirement that tribal remedies be exhausted. That was a doctrine in federal courts before, but it was not a statutory requirement. So you can see here, this is now a requirement that defendants exhaust their tribal court remedies before filing this habeas petition. And also it notes that it's after a defendant has been sentenced. So that's important too. They can't just, you're gonna timely notify this defendant, right, of their right to file a habeas. That doesn't mean they get to file right away. They actually have to exhaust their remedies, and that has to be after they've been sentenced. Now there's a couple exceptions here. If you look under 2B and C, where there's an absence of an available tribal corrective process. That's typically, in terms of the state courts, how federal courts have applied this, interpreted this language for state courts, is where if there just really isn't an appellate court, but that's really not going to be the case for most of our tribes that are implementing VAWA. Or C, circumstances exist that render the tribal corrective process ineffective to protect the rights of the applicant. Some of us were concerned when this language was added because it's a little bit unclear what it means for a tribal corrective process to be, quote, ineffective. However, there's a wide body of case law interpreting this exact same language from 28 USC 2254, which is the analog to this for state court conviction challenges through the habeas petition process. So I think as attorneys who are defending the sovereignty of our tribal nations and who will be defending against these habeas corpus petitions, if someone is trying to rely on subsection C of 2 here to avoid having to exhaust tribal court remedies, I think one of the main arguments or points we are going to want to make is that there's already a body of case law interpreting what it means to be ineffective. And we can research and look at that. Federal courts have already defined that, and that those same standards should apply here. And that really, as the goal here of this language, is to put tribal courts on par with state courts, so that just as state courts are respected as separate sovereigns with their own criminal justice systems, so are tribal courts, and they aren't due any less respect than their state counterparts. Just want to show you, this is the language that actually is in the Indian Civil Rights Act. It just says the privilege of the writ of habeas corpus shall be available to any person in a court of law in the United States. This, of course, my own video feed is covering up the right side of the language here, to test the legality of his detention by order of an Indian tribe. So with that, I think that is my presentation, and I see we have some questions. So I'm going to start answering these questions. Just looking at, and if you have any questions on anything related to VAWA 2022, please drop them into the chat, and I will now, yes, so the slides will be available. I've sent them to everyone hosting the session today. I'm very happy. Please use them, share them widely. They're meant to be helpful and informative. Yes, let's see. Can Native Americans apply for VOCA? Yes, so VOCA funding is available. That's an entirely separate vehicle than the VAWA funding. And I would check with your tribal coalitions in terms of how the VOCA funding is being handled. They're going to know about that. But that's something I would look to your tribal coalitions to answer, because it's actually not directly a part of VAWA. Let's see. Oh, yes, I'm very happy. So I've been asked to put my email in the chat, which I will do right now. Let's see. I have, That's one email, and you can also reach me at my personal email, and I'll give you both, and either one is fine. And I'm happy to answer any questions. Oh, great. I see Tiffany gave a contact there for questions about VOCA funding. Thank you, Tiffany. Are there any other questions about any of the aspects of VAWA that we've discussed so far? Housing in VAWA. This is a great question. So that was actually a separate title. And I'm actually not the most familiar with the housing issues in VAWA. That was, again, it's outside of the tribal title. What I'm going to do, and I apologize for punting, but there is an expert on housing, and she's at NIWRC. And how come I'm not finding her email right now? So NIWRC has someone who works specifically. This should be her email. So I'm going to share this. Caroline Laporte does all the work for housing for the National Indigenous Women's Resource Center. And so I would recommend emailing Caroline, anyone who has questions about housing under VAWA, because she worked extensively on that. And I just, unfortunately, it's not, I don't want to provide any misinformation. Next question, is BIA law enforcement to be trained? Yes, is the easy answer. I will say that there are several folks who do that training. OTJ provides TA in many instances. But I think that, in terms of BIA law enforcement, keep in mind that's not really what's a part of VAWA. VAWA is about restoring tribal criminal jurisdiction for our tribal law officers. And so VAWA doesn't really directly impact BIA law enforcement training in any form or fashion. And so I think all of us, those of us living in Indian country, I think BIA law enforcement's provided some really important resources and protections to our community, but also I think we've seen in many instances, and I'll say, especially with some of my clients that I've worked for in Montana, and I know it's not just in Montana, it's with other tribes throughout Indian country, there've been a lot of instances of BIA law officers raping, abusing, and in some instances shooting without cause, killing Native people, Native women and children. And I do think we need some very serious overhaul of BIA law enforcement and training. And all you have to do is look at some of the cases right now coming out of Montana. In fact, there's going to be a Supreme Court oral argument in the Montana Supreme Court on April 15th. Involving a case called LB versus United States, where BIA law enforcement actually raped a Cheyenne woman after she called them for help. They showed up at her house, raped her, and she's suing under the Federal Tort Claims Act, and BIA is arguing they're not liable for the law officer's conduct because it was outside the scope of his employment, and so she can't recover any monetary damages from BIA. A pretty disgusting argument for our United States federal government to make. The NIWRC filed an amicus brief in that case, along with the Blackfeet Nation and Fort Belknap, arguing to the Montana Supreme Court that Native women who are raped by BIA law officers, at the very minimum, should receive damages from the federal government. And that's at a minimum, because we do need more training for BIA law enforcement. Let me look to the next question. I agree, Caroline is amazing. Definitely reach out to her. Why was elder abuse not included? I do not know. And I want to be careful in criticizing our friends on the Hill because they did such good work in this VAWA reauthorization. They worked really, really hard to get VAWA across the finish line. I had many people, specific lobbyists who are very staunched in DC politics, tell me that I was a dreamer, that it was a pie in the sky dream. It was never going to happen. There's no way that a bipartisan VAWA is going to happen because, McConnell wasn't going to let it happen, or, you named the Republican person who was supposed to be opposed to this and it wasn't going to happen. And so we worked very hard with both folks on both sides of the aisle, especially with the Senate committee, to get this done. That said, I do not know why they took elder abuse out. They wouldn't tell us. They wouldn't really engage on that topic. We had numerous tribal leaders write to them and say elder abuse needs to be included, and they kind of just ignored that. So I think this is one of those moments where we want to thank all of our staffers and members of Congress on the Hill who did hard work to get so many critical categories of jurisdiction restored, but there should always be accountability. And I think the Senate Committee on Indian Affairs needs to answer to tribal leaders. When tribal leaders write to the Senate Committee and say, this is not okay, we need elder abuse included, they can't just ignore that. And so I think it's very fine and appropriate, especially for tribal leaders, to let their members of Congress know how disappointed they are that elder abuse was taken out, because our elders are sacred. And it just sort of is antithetical to some of our most traditional values to discard our elders in that manner. And so I think it should be said, and I encourage tribal leaders to have those conversations with their members of Congress. And again, I wish I had more to say, but I asked the question and was just ignored. No one ever gave me an answer. What can we do to have BIA involved in training? Well, that's a good question. I'm not quite sure how to answer that. I mean, of course, we can reach out to BIA and encourage them to be involved in training, but a lot of that right now is really at the discretion of Assistant Secretary of Indian Affairs, Brian Newland, as well as the head of OJS, Jason O'Neill. And I think to the extent people feel comfortable reaching out to those leaders at the department and advocating for whatever kind of BIA law enforcement training you're hoping to see, that might be the best course of action. So I have another question for our tribal leaders at the next DOJ consultation in September. What are the major issues on the federal level that they should be aware of and advocating about? We are celebrating this win, but understand so much work lies ahead. How can we get them ready? Oliphant fix, ARPA funding, great question. So I do think Oliphant fix, right? I think we have to stay consistent with that messaging. I understand that it's not going to happen today and it may not happen tomorrow, but it's going to happen. We're on a trajectory towards a full Oliphant fix. That's what VAWA 2013 is about. That's what VAWA 2022 is paving the way for. And that's what all of the work that we're doing in the Supreme Court right now in defending tribal jurisdiction and sovereignty in the briefs that we're filing across Indian country through all these different cases, we're setting ourselves up for this full Oliphant fix. So we have to keep telling Congress that and DOJ that that's what we need, right? Beyond that, I think we have several critical issues. One, of course, is always funding and resources. DOJ is doing a decent job of getting the funds out, but they are not always consistent. And so I think they need to understand just how important it is that they fulfill their trust, duty, and responsibility to fund our tribal governments. I think there's a little bit of a concern with DOJ at the moment, and let's just be honest, right? There is no political appointee at the Department of Justice that's Native. So we don't have a political to go to for Native issues. And so what a lot of other agencies are experiencing some frustration with is that DOJ comes to certain conclusions on how laws of general applicability passed by Congress apply to tribes when tribes are not mentioned in those laws. And we have an understanding that if tribes are not mentioned, then, OSHA or these other requirements don't apply to tribes, right? Unless tribes are spelled out in those laws. But without a Native political appointee with that kind of subject matter expertise at DOJ, we don't have a political appointee that folks can go to or that can advise the Attorney General on this. The other thing I will say is that I think we're very thankful to the Biden administration for their leadership on missing and murdered Indigenous persons, but not much has happened. And I will say for the families that I've represented, they have written numerous letters to the missing and murdered unit that was created under Secretary Holland. They have yet to get a single official meeting to discuss why or why not their child or their daughters or their nieces or their granddaughters' case is being investigated or not investigating. We've had a whole year go by where our correspondence has really not been responded to, or an agent's been assigned, but the agent won't communicate with the victim's family. Or I had one instance where the agent refused to respond to any of my emails and calls and just showed up at the victim's house, kind of banging on the door, demanding to talk to the family. And that really triggered the family because they weren't sure, they didn't want to talk to the agent without their advocate, without their attorney present. And so a lot of the communication has been somewhat dysfunctional. And I think we all need to advocate for respect for our victims' families, that they be prioritized in terms of communications, that if we have a mother whose daughter's been murdered and she reaches out to the missing and murdered unit and says, I want you to work with my victim advocate from this tribal coalition, or I want you to work with this person from Sovereign Bodies Institute, or I want you to talk to my attorney, to respect that and to engage in those communications in a respectful manner, and to not make a decision about the case until they have talked to the family. So the other thing that's happening is the missing and murdered unit is deciding whether or not to investigate a case based on the file they have. And the file they have does not have all the evidence because it's a file created by either the FBI or local law enforcement who did not do an actual investigation. That's why we have a cold case. That's why there hasn't been a prosecution. And so for the MMU at the DOI to make these decisions without even talking to the family, they're not going to be aware of the eyewitnesses or the other evidence or important information that the family has before making a determination about whether or not to take the case. Now, this all factors into DOJ because DOJ needs to be working with DOI on this. But we really don't, I don't know who's there right now, who is the point person really working on this, but I think they need to understand just how important it is. We've got these executive orders, and that's wonderful. The Attorney General, Merrick Garland, is supposed to be crafting MMIP protocols and guidelines, but those need to be crafted in consultation with tribal leaders and also victim advocates, right? Victims' families need to be a part of that conversation because so often our victims' families and their advocates are being left out. And so how is that going to come about? I will say it's just not quite clear yet how that's going to come about. But I encourage people to really advocate for the involvement from our victim advocates in that nature. So are there any, I know we're running short on time. Are there any other, Janine, I don't know if you have anything to jump in and say.
No, we're actually at time, but thank you so much, Mary. That was a very detailed and informative presentation. All very wonderful and concise how you broke down so many different complications, but also a lot of the real opportunities that exist for tribal leaders to effectively define and codify key parameters and legal definitions and protection of our, sorry, I have a cat.
I love it.
Protection of our people and our most vulnerable. And I especially want to, echo your recommendation to engage with victim advocates to create the most informed protections for our most vulnerable, and how our leaders and our advocates can be proactive and prepare to get in the proper codes and do all of the work necessary so that by October 1st, 2022, many of our communities are hitting the ground running. And so also appreciate the way that you've emphasized that the work that can still be done for the Oliphant fix, and just how that can be the focus for a lot of the coalitions and people who are continuing to come together and dedicate their time to this work. Really appreciate it. We'll make sure that your presentation gets out to the attendees. Thank you personally for all that you do to support Native women and children and your tireless work. To our attendees, we'll now leave this room and go into the next by clicking on the session name, Sovereignty and Safety, on your left. And so we will leave this room and see you there.